We've seen Sarah Boone over and over again remind the judge, that she was forced into pro se in her letters in open court.
Forced to represent myself as pro se, me representing myself in 62 days.
I believe that it is unfair that you, number one, want me to represent myself.
I don't want to be pro se any longer, so I didn't want to be pro se in the first place. In my opinion, unlawfully denied me or didn't even suggest an evidentiary hearing in order for me to avoid or try to go about a solution or remedy.
And it seems like there's more drama behind the scenes with her former attorneys. I don't know if they got paid yet. But before we get to that, I want to go back to the August 14 hearing where Sarah Boone requested for a neuropsychologist. You guys remember at the very end, she handed the motion to the judge. The judge reviewed it and was like, you know what? I think we need JAC here. So we actually have her motion filed. She requested for a neuropsychologist and she explains why she might need one. And it could help to have an expert to go up there on the stand to try to humanize her even more to the jury. You know, because it's going to be hard for the jury to overlook her recording the video of George in the suitcase. And I watched it recently again, and every time I watch it, it just gets worse and worse. Oh boy. Okay, here we go. Now, this one is not very long because she's not complaining about her conditions. 5 pages, not too bad. Motion for payment of costs and appointing neuropsychologists to assist the defendant in preparation of the defense. Oh, I also want to point out, remember I told you guys that I was on the court website and I was like, there's 151 pages that's been uploaded to the Sarah Boone case. I couldn't open it because I was on my phone, but I found out what it was. Now, the reason why it was so long is because this is JAC providing Sarah Boone a little JAC policies and procedures for people who are going pro se. Remember, they kind of help her out a little bit because she doesn't know what she's doing, and it would be better for the court if she has her stuff in order. Things can go by faster. Doesn't have to be back and forth, frustrating for her. So they give her like an outline of like the policies and stuff like that. What's really cool is that they have templates that she can use. So when she's requesting for, I don't know, like when she wants to hire like an expert or something, or do like depositions and get transcripts, costs and all that stuff. So they have all this for her to use. And not only that, they also have at the very end, the rates, how much it would cost for certain experts. So we have like psychological evaluations, medical doctors, other experts, in-court testimony, travel time, and all that, just so she can work with these other experts in her case. Not only that, they have a vendor list that has like accident reconstructionist. Ooh, I wonder if Trooper Paul is on here. I'm just kidding. Trooper Paul. Accounting. These are all the contacts that she can reach out to. I'm assuming this is like for languages, maybe like interpretation, audio, video forensics, ballistics, firearms. So this is actually really handy to have a list of people that you can reach out to. And assuming since they're listed on the JAC vendor list, I'm sure their rates would probably comply with JAC. You got biomechanics, blood splatter, cell phone tower, cellular tower mapping, chemist, child abuse. So all this stuff right here, which would be very useful for someone who's going pro se. And if they don't have an unlimited amount of time to research their experts, they can have a little, you know, like this right here. So I think that's really useful. Anyways, I just want to bring this up because when I was searching for pro se stuff in Florida, I couldn't really find much. Motion for payment of costs and appointing neuropsychologists to assist the defendant in preparation of the defense. I was wondering why she wanted to hire a neuropsychologist. I think I came up with some, I don't know, maybe like little mini theories, but now we're gonna get the answer. Comes now the defendant, Sarah Boone, by way of pro se, respectfully, moves this honorable court to enter an order authorizing the state of Florida to incur costs of the following discovery expenses. 1. Reasonable fees for a neuropsychologist. These services include the reviewing of the documents and physical evidence, writing of the reports, travel, and trial testimony. As grounds, the defendant states the following. A. Defendant's charged with second-degree murder. Yep, she's looking at possible life in prison. B. Defendant has been adjudged indigent for cause. C. Defendant has no income and cannot afford the services of a neuropsychologist. D. A genuine issue exists relating to this case which will require the assistance of an expert witness in the field of neuropsychology. E. Defendant is without funds and does not have the ability to pay the costs associated with an expert witness to assist in the defense of this matter. Therefore, she requires the assistance of the state of Florida to guarantee protection of her right to the process and effective assistance of counsel. Effective assistance of counsel. If counsel has contacted neuropsychologist Dr. Hyman Eisenstein. So look at her. She's doing some work. G. Defendant intends to engage the services of Dr. Hyman Eisenstein. Dr. Hyman Eisenstein graduated from the University of Chicago Division of Biological Sciences. the Fitzger School of Medicine in 1982. He works in Miami Beach, Florida, specializing in psychology. Age, defendant seeks permission to allocate funds from Dr. Hyman's Eisenstein services at a rate of $300 per hour for all the work performed on the case, except travel time billed at $125 per hour with the initial cap of $15,000. $15,000, that seems kind of high. Is Dr. Eisenstein on the JAC list? Let's see, neuropsychologist, find out. Investigator, psychologist, mental health expert. Do you think they're gonna have a neuropsychologist? Oh wait, I'm all the way down here. Toxicologist, neuropsychologist. I mean, I think these are just all psychologists. I don't know if they have like a neuropsychologist category. Wait, is that it? Dun, dun, dun. Oh, here it is. Let's see, is Eisenstein on here? Neuropsychologist. I don't know, some of these are just office names. I don't know if I see Eisenstein on here. This is Miami, right? Tampa, Miami. Here's a Miami here. We don't know which physician. Tampa, Austin. Wait, Austin, Texas. I don't see an Eisenstein on here. So I don't know if she got it off the JAC list or if this is someone that was recommended to her, or maybe, I don't know, maybe her former attorney reached out to Eisenstein and then it didn't work out or something. Okay, with an initial cap of $15,000 plus reimbursement for all reasonable and necessary related expenses. Geez. Including but not limited to travel expenses, lodging, meals, mileage, postage, shipping, and document reproduction, and is a service provider with the JAC. Oh, they're a service provider with JAC. Wait, so she found them through JAC, it seems like. Defendant cannot properly prepare for trial until expert analysis is complete. Defendant has attempted to request this evaluation through her previous appointed attorneys without success, based on several factors, include the attorneys not being able to locate the proper specialist. Okay, so we are gonna go back to her former attorneys and rehash open some of that drama, because now it's so interesting to see things in hindsight now. Before, as we're reading all the Sarah Boone letters, we're kind of just like going through it, as it was happening. But with how she's been with her former attorneys, with the conduct that she's conducting right now while in court, and completely, what am I trying to say? And continuously reminding the court that, oh, I didn't want to be pro se. This is a forced position. And she does it in her letters too. Now it's kind of interesting to see the whole thing happen again, but in retrospect. So we're gonna go through all of that, because we're gonna go over the judge's order, and then we're gonna go over the judge's orders included in one of her former attorneys' complaint about not getting paid by the JAC. You're like, oh my gosh, imagine working with Sarah Boone and you're not getting paid for that. But we'll get that in a bit. Oh boy. Okay. So neuropsychologist. Okay. So the attorney not being able to locate the proper specialist in this field of neuropsychology, the willingness of the neuropsychologist to work the case, and the authorization of the JAC to pay for said neuropsychologist. Okay. So it seems like former attorneys couldn't get a neuropsychologist that wants to work the case. They couldn't get someone to authorize according to the JAC prices, maybe. And then, yeah. Okay. Defendant believes that her pattern of behavior stems, so now we're getting the reasoning why. Defendant believes that her pattern of behavior stems from a lifetime of mental and physical abuse, and believes that she cannot have a proper defense without a neuropsychologist who can evaluate her exposure to this trauma. Again, the neuropsychologist can help in assisting her by going up there and testify, maybe talking about the trauma that Sarah Boone has experienced, which led her to become who she is today. And you know what's interesting? Sorry, I'm just going to go off the tangent here because I saw this morning. This is a video of someone reacting to another video. So it's a little bit scuffed, but I just want to show you guys. Look at that. Who is that right there? Teenage Sarah Boone on Nickelodeon. What is it with, I think we saw Lori Vallow. Wasn't she on Wheel of Fortune? I think she did pretty well, right? Or was that Donald Adelson? I don't know. There's so many of these people that were on all these game shows. We had a Wendy Adelson who was on one game show. I don't remember which one. Donna Adelson, I think she was on Wheel of Fortune. And then Lori Vallow. Was she also on Wheel of Fortune as well? I don't remember. Holy shit, Sarah has had the same haircut her entire life. So I'm just gonna, she's recording, I think her iPad. Okay. I just want to get to the part with the game show.
To where she is now.
Your partner there, Sarah, likes to hang out at the mall. Now, what do you do while you're just hanging at the mall, Sarah?
Well, check out guys and spend money.
Check out the dudes and spend the cash. Your cash or like parents' cash?
Mine.
That's a young Sarah Boone right there. I mean, that looks like her too. At first I was like, is that Sarah Boone? Maybe they found someone that just looks like Sarah Boone, but it seems like it might be Sarah Boone on a game show. So it's so crazy. I don't think there's much in this. I don't think we get more footage of the game show. It's just like a little bit of footage here and there. But here's the video if you guys want to check out the original one, Con Jeans. And then they're reacting to another video. And then you can see what video they're reacting to. So it's like a triple reaction is happening right now. But I mean, yeah, Sarah Boone on a game show. Let's see what's on over here.
I have Mark of the yellow team and Sarah of the red team gonna play the face-off Crater Ranger. Now remember, in this game, you have to maneuver your ATV over dangerous alien landscapes. You have to avoid craters and explosions and other pitfalls. Sarah and John, and they're psyched to go through that door into the video zone to battle Scortia. Now, you have 1 minute to get through all 3 levels. All right, into the zone there with you and extinguish Scortia's flames. Go through that door. Yeah. Now, all right, Sarah's on her way. Flying along. That was a great time. Hey, she's up. Bam, there's 1 ring. Stand low.
What a throwback. Oh my gosh. I don't know if I remember this Nickelodeon game show. I used to love watching Nickelodeon, but I think maybe this was before my time. Also, who found this? How do people find this? Like, how do people find like all these other people on these game shows? They just come across my YouTube. There was another one where she was like, you can see her talking a little bit. I mean, it's just so interesting to see a person in their youth and to see what happened to them. Like, in a world where you could be anything, why be a narcissistic asshole?
Name the type of orange that sounds like a belly button. Yes, red team.
Navel orange.
Navel it is. Yeah, there you are. The audience likes the navel thing.
She looks so young. Oh my goodness. Anyway, I'll link the video down below. The only thing that we really know about Sarah Boone from her ex-husband through the body cam footage, he does mention that Sarah Boone does seem to have like an alcohol problem. And I think it was also mentioned in George's brother's interview with law enforcement as well. So I was trying to make sure that I had all that correct. I haven't posted that video yet. I guess maybe I'll do that today because we did watch it on stream, and then I'll post the original video for you guys as well. All right, so now back to this. Defendant believes that her pattern behavior stems from a lifetime of mental and physical abuse and believes that she cannot have a proper defense without a neuropsychologist who can evaluate her exposure to this trauma. Oh boy. A neuropsychologist specialized in understanding the relationship between the brain and the behavior. Given the complexity of the defendant's mental health history, it is critical to assess her cognitive functioning and the mental state to determine how these factors may have influenced her actions. Like I said, I watched the video of George inside the suitcase recently where he's begging Sarah to unzip and he was like not able to breathe and she just didn't care. I don't know. She just sounded so childish on the fucking video and it's just so horrible that that's how George died. Like what a way to fucking die. Oh God. All right. Wherefore the defendant Sarah Boone by way pro se respectfully requests this honorable court in conclusion for payment of costs and appointing neuropsychologists to assist the defendant in the preparation of the defense. Now let's get to JAC's response and see what they have to say about her requesting $15,000 plus for this neuropsychologist. It don't look good. Justice Administrative Commission's response to motions for payment of costs and appointing neuropsychologists. Comes now that a JAC by and through the undersigned attorney files his response to the above cited motions as follows. 1. Defendant is seeking authorization for $15,000 at a rate of $300 per hour services and $125 per hour for travel for a specialized mental health expert. Based on JAC's records, the court previously authorized $3,000 at a rate of $200 per hour for a defense mental health expert. JAC may only pay for due process costs pursuant to Section 29, as directed by blah, 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 and blah, blah, blah. All due process services are subject to the Florida statutes and the JAC contract, policies, and procedures. In bold, JAC objects to any compensation rate in excess of the established rates. The rate for a psychological examination is a flat fee of $350. For other services, and this was attached in the JC packet that they gave her. For other services, the established rates for medical doctors and psychologists are as follows. In court testimony, $170 for the first hour, $170 per hour afterwards. Why not just say $170 an hour? Oh, $170 for the first hour or less. Okay, or less. B, waiting to testify in court, $85 an hour. Waiting to testify deposition, $17.50 an hour. Travel time, $17.50 per hour. Out of court services, $160 for the first hour, and then $160 per hour thereafter. So, yeah, it seems like that's going to get denied, and she's going to have to find someone else. I mean, maybe the ex would be willing to work at the JAC rates. I mean, if they were found on the JAC vendors list, maybe they'd be willing to work that out with Sarah Boone, or she'll just have to find someone else on that list that they gave her. The defendant has a burden to show the particularized need for the additional mental health expert. The defendant needs to show the services of the expert is necessary for the defense of the case. Yeah, because I remember that, I forgot which attorneys. I mean, it probably was like all the attorneys, but there was like an attorney in particular, maybe two of them, where they were working on getting a mental health expert, and then they were getting delayed because JC was, I think it was like delays with like the JC payment. Was that Frank Bankowitz? That could have been Frank Bankowitz, and could have been with the mental health expert. Because I know Frank Bankowitz was trying to work with getting some experts in, but they were having some issues with coordinating with JC and stuff like that. Okay, as enunciated by the Florida Supreme Court, a party seeking due process cause has the burden to establish 1, the particularized need for the due process services, 2, prejudice arising from the denial of due process, 7, determination of whether to appoint an expert is within the broad discretion of the trial court. An indigent defendant must show the trial court that there exists a reasonable probability both to an expert would be of an assistance to the defense, and that denial of expert assistance would result in a fundamentally unfair trial. 8, defendant has the burden to establish diligent efforts to obtain services within or closer to the rates, within or closer to the rates established by a law. Assuming the defendant established a particularized needs for the specialized mental health expert, that rate sought is consistent with the rates authorized for similar experts in other cases. 9, if any provider desired direct payment, the JAC's procedures require the vendor to execute the appropriate contract and follow JAC's billing and audit procedures to obtain payment. JAC does not request to participate in any hearing set in this matter. Should the court desire JAC participation, JAC requests to appear, communication through communication equipment and can be reached toll-free. Oh my God, they gave a toll-free number, 866-355-7902. Wherefore, the JAC request should be the court grant the defendant's motion, also include in its order the specific due process services authorized, as well as hourly or per unit rates and maximum fees authorized, and that the provider be paid in accordance with rates, terms, and conditions set forth by Florida statutes and the JAC contract and the policy and procedures. So we'll see what the judge decides. It seems like Sarah's probably gonna have to go back and speak with his expert and say, hey, are you willing to work at these rates instead? These are the rates that I'm only approved of. Maybe I can do a little bit more. Maybe I can talk to JAC, or she just has to find another expert. But like I said, they gave her this packet thing. So there's a list of other neuropsychologists that hopefully maybe her private investigator can reach out to. Would that be a private investigator thing? Because private investigator could probably reach out to the witnesses and like maybe assist with all that and depositions and stuff like that. But like in terms of like treating your private investigator as an assistant and like, hey, can you reach out to the neuropsychologist because I only have 15 minutes a day on my payphone? I don't know. I guess it depends on it depends on the PI. Maybe they'll do it for her. We'll see. Now, going on to the next segment. So like I said, Sarah Boone will remind us over and over again that she does not want to be pro se. She's unprepared. She doesn't know what she's doing. And this was a forced thing that was put upon her, not by fault of her own, and then it was the fault of all the other previous attorneys that were court appointed to her, and then her other attorney was actually a private attorney, so that was not court appointed. But it's everyone else's fault. And you know what? We're going to revisit that because this popped up right here. Oh man, if y'all remember Mr. Winston Hobson. Mr. Winston Hobson was attorney number 7, I believe. So we had 6 was Frank Bankowitz. 7 was Hobson, 8 was Patricia Cashman, 9 is Sarah Boone, per se. Well, this popped up, and it seems like Winston Hobson is having issues with getting payment from JAC. He He's asking for a flat rate fee of $15,000. JAC seems to object to it and said that if you want this attorney fee, well, you're going to have to put in a court order and then maybe figure it out amongst the other attorneys that are also on Sarah Boone's case. Because from my understanding of this, it seems like you get a flat rate fee of $15,000. But because there are so many other attorneys on Sarah Boone's case, it might need to be split up amongst other people. But imagine if you worked a lot of hours, and depending what your hourly billing is, if you exceeded, let's say it's like 15,000 divided by 4 people. If you exceeded that amount, then it kind of sucks. But they want a flat rate fee of $15,000. So this seems like a headache for Mr. Winston Hobson, but I want to read this. And then within Mr. Hobson's motion, we also have attached the judge's order when he made her go pro se. And the reason why, like I said, I want to go over that is because it's interesting to see everything now in retrospect. Okay, let's start with Mr. Hobson's motion. I'm sorry, it's a little bit blurry. I would just read it to you guys. I don't know if you guys want to read it yourself, but I'll do the blurry reading for you. Comes now Winston E. Hobson, Esquire, as a private court-appointed attorney in the above entitled cause, and files this motion for attorney's fees pursuant to section in support thereof states as follow. 1. The undersigned, Winston E. Hobson, was duly appointed to represent the defendants September 8, 2023, so about a year ago. 2. The undersigned is now billing on this cause because the case has reached final disposition in this representation. The Justice Administrative Commission, JAC's, response to the billing was to object to the flat fee amount of $15,000 for attorney fees, and a hearing is requested. A copy of the objection letter is attached. A copy of the order on June 28, 2024 is also attached. I don't know if they're going to stream this because it's like related to Sarah Boone, but it's adjacent. You know what I mean? Like, I still want to see this hearing though, if they have it. Number 3, the undersigned counsel represented the defendant from the date of February 9, 2024, when the court discharged counsel and appointed attorney Patricia Cashman. Defendant now represents of herself after discharge of attorney Cashman, and the order of appointment of undersigned counsel is on file with the JAC. The defendant was ordered to represent herself. 4, the defendant was charged in the above styled cause with 1 count of second-degree murder. The maximum sentence the defendant faces is life imprisonment. 5, because of the length of representation in this case, the volume. So now we're going to know, okay, what did Winston Hobson do in the background? Because of the length of representation in this case, the volume of discovery, the witness list, the complexity of the issues, counsel is seeking payment of a flat fee in this matter. This case involved voluminous pages of discovery, filing 2 or more banker boxes, photographs, numerous hours of audio, video statements in this case, viewing a voluminous amount of video material in the public domain, hours of consultation and discussions with an expert psychologist. So I wonder if Sarah Boone doesn't want to use that expert psychologist. Maybe she doesn't like what they're saying, or maybe she wants to use them with the addition of the neuropsychologist, maybe. Discussions with an expert psychologist in attempt to develop defenses in this matter. Letters to and from the defendant. Ooh, those letters. Video and in-person visits with the defendant at the Orange County Jail. Numerous consultations with the investigator, in-person visit at the jail with the investigator, Mr. Billy Lane. Counsel reviewed numerous and very extensive letters from the defendant and did extensive review and research into legal matters, many at the defendant's request. Counsel spent no fewer than 200 hours on this representation. Counsel copied and sent over $400 copy costs. Also, going back to Mr. Hobson researching and reviewing legal matters at Sarah Boone's request. I think Laura, thinks that Sarah Boone is working with maybe like a jailhouse attorney or some sort, where they're also like an inmate there as well. And maybe they're the ones that are trying to assist with Sarah Boone's defense. And maybe they're giving her all these ideas like, okay, well, tell your attorney to research this, research that, do this, do that, do that. And then maybe their advice is clashing with the advice of her court-appointed attorneys. And that's why she thinks that they're ineffective, or she thinks that, they're working against her. So I don't know. That seems to make sense to me as well, if that's happening. Counsel copied and sent over $400 copy cost of information to the defendant. Until a quarter is entered, JAC will not refund this amount. Oh my God. JAC seems like a like a headache to work with. Okay. I'm just saying, I don't know. Maybe they are easy to work with, but just imagine doing all this work for someone and then having those costs be approved. And then they're like going over everything line by line. I don't know. That to me would be like, so like what if you don't get paid for the work that you're doing, you know? Number 6, undersigned counsel has submitted a voucher to JAC for payment. I wonder if he has a breakdown of all the hours spent and his billable hours and all that stuff. Number 7, Florida statutes 2704 states a private attorney appointed by the court from the registry to represent a client is entitled to payment as provided in section 275304. The Florida statute states JAC Commission shall review the intended billing by private court-appointed counsel for attorney fees based on a flat fee per case for completeness and compliance with statutory requirements. So that's where I guess JAC is saying, they're like, oh, well, technically you didn't complete this case. You know, you had a motion to withdraw through, you know, because of irreconcilable differences. So you're not going to get the flat fee of $15,000. I'm guessing that's what their stance is. The commission may approve the intended bill for a flat fee per ease for payment without approval by the court if the intended billing, is correct. If it's correct. So maybe they're saying that like, oh, okay, we need like a breakdown of your hours spent and like maybe it's not lining up with him getting the $15,000 flat fee. An intended billing that seeks compensation for any amount exceeding the flat fee established for a particular type of representation as prescribed in the General Appropriations Act shall comply with subsection 11 and 12. 12. The legislature recognized that on rare occasions, an attorney may receive a case that requires extraordinary and unusual effort, which could be with Sarah Boone. A. The counsel seeks compensation that exceeds the limits prescribed by law. He or she must file a motion when the chief judge for an order approving payment of attorney's fees excess of those limits. So that's what he's doing right now. D. If the chief judge or designee finds that a counsel was proved by competent and substantial evidence that the case required extraordinary and unusual efforts, the chief judge or designee shall order the compensation to be paid to the attorney at a percentage above the flat fee rate, depending on the extent of unusual and extraordinary effort required. The percentage shall only be the rate necessary to ensure the fees paid are not confiscatory under common law. The percent may not exceed 200% of the established flat fee with an absence of specific finding that 200% of the flat fee in this case would be confiscatory. Confiscatory? It's a confiscate, right? Confiscatory. Okay. If the chief judge or designee determines that 200 blah, blah, blah. So I don't think I'm going to read all this. So anyways, number 9. Undersigned counsel has attached and made part here in the objection letter and order of the court. We're going to read the attachment. Number 9, as a result of undersigned counsel's acceptance and work on the above styled case and the incredible demands of the case on the defendant, the extreme consumption of time and effort daily for the duration of the representation, counsel often had to set aside various work demands and other activities. Lost opportunities resulted. 11, prior and after undersigned counsel being appointed, other attorneys and since appointed to represent the defendant. Those attorneys also did very significant work in this case as evidenced by their motions for attorney's fees with various attachments. They too were rejected by JAC to receive the flat fee in this cause. We can probably find out how much they end up getting maybe. Because of what is outlined above, the work done by the attorneys failing to pay each the flat fee would be confiscatory. Wherefore, it is respectfully requested that a court enter an order approving the amount of $15,000 for attorney's fees, directing that the undersigned be compensated by the state of Florida. Because I do remember Patricia Cashman did request for attorney fees, if I remember correctly. All right, so this is the letter where JAC objected to Mr. Hobson getting his $15,000 flat fee. JAC objects to your billing for attorney's fees in the amount of $15,000 for the following reasons. Your date of appointment on this case was 9/8/2023, and I think he was on there till February, right? So September, October, November, December, January, February, it's like 5 months. The legislator established flat fees of $15,000 representation of felony non-capital murder case. Multiple attorney case. So this is the reason why they're not going to give him the flat fee. The aggregate amount billed for attorney's fees amongst all attorneys appointed to represent this case exceed the flat fee established in the General Appropriations Act. The General Appropriation Act comprised the full or complete compensation for private court-appointed counsel. Paragraph blah, blah, blah. Contract provides for any case subject to a flat fee if attorney withdraws or is discharged prior to the completion of the case. I wonder if when the attorney withdraws, I wonder if it depends on what their reasoning is, you know, or if it's just like, if you just withdraw period, then you're not going to get the entirety of the flat fee. Because then, you know, say bye-bye to Patricia Cashman getting this flat fee, bye-bye to Frank Bankowitz getting this flat fee. If the attorney withdraws or discharged prior to the completion of the case, attorneys shall only be entitled to a portion of the flat fee to be determined by the court. Okay, so the court's going to determine that. Where the court appoints more than one private attorney, the total compensation for the initial and all subsequent attorneys may not exceed the flat fee. Yikes. You were appointed to this case but did not represent the client through the entire course of the case. Thus, the court appointed more than one private attorney to represent this client. Pursuant to the court must apportion the flat fee among all private court-appointed counsel who work this case. In this matter, you were third of four attorneys appointed to represent the defendant. Yeesh. Like I said, I wish I could see a breakdown of his billable hours and all that, and like how much hours did he do for like each task. Because the court must apportion the flat fee among all private court-appointed counsel, the matter must be heard before the court in a single hearing. You will need to coordinate the hearing date and time with JAC. Oh gosh, and all the attorneys listed below. In this case, the following private court-appointed attorneys represented the client during the following periods. So did they... Because they billed $15,000. Did they get it? Okay, so now this is where we get more information. Mark Conselo. So I think Mark is the first guy that was appointed to Sarah Boone, but then Sarah Boone got Padilla instead, a private attorney who she had for 2 years. And I think during that representation, we didn't get any letters during that time about her complaining. We did get letters subsequent to him withdrawing about her complaining about Padilla, if I remember correctly. Frank Bankowitz, attorney number 6, dates appointed July 11 to, oh gosh, she was with her for about a year and 2 months. September 8, 2023. Winston Hobson, September 8 to February 9. I think like each date just gets shorter and shorter, it seems. Patricia Cashman, so bill $15,000 for Frank, bill $15,000 for Winston. Patricia Cashman, dates appointment February 9 to June 28. Case open, no billing to this date. Order discharging counsel and finding that the defendant has forfeited and waived her right to counsel. The trial court will decide the amount of compensation with each attorney is entitled. Wait, so did Frank not get paid yet? Frank? As to your representation, the decision is based on the work performed from 9/8 through your discharge from the case from 2/9/2024. If the attorneys are agreeable to the division of the flat fee, the attorneys may execute an attorney settlement agreement for splitting flat fee located at, here's the form that they can all fill out to divide the flat fee of $15,000. When the attorneys seek total compensation in excess of flat fee, the attorneys must follow the procedures and requirements established in blah, 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 blah. The chief judge or designee must hold an evidentiary hearing on this issue, whether to exceed the flat fee. Jesus, more court time, more time spent to figure all this out. So that's Mr. Hobson. Now, Mr. Hobson, he's going to attach this order by the judge where he allowed Patricia Cashman to withdraw and then also made Sarah Boone represent herself. Now, like I said, I want to go over this again because it's kind of interesting to see how this all happened, but in the aftermath. So I'm just going to read this for you guys. Oh, and also, I already read this, I think, maybe a couple months ago. Yes, this is June 28th. So this is just a refresher for those of you guys, you know, like I thought it was kind of interesting to go through it again. Okay. Okay, so procedure history. February 26th, the Office of Public Defender, 9th Judicial Circuit in and for Orange County, Florida. Public Defender and Attorney number 1 was appointed to represent defendant. On March 9, 2020, the Public Defender moved to withdraw due to defendant retaining private counsel, Mauricio Padilla. On April 18, 2022, Padilla moved to withdraw due to irreconcilable differences arising between the undersigned and defendant that have made it impossible for the undersigned to effectively represent his clients. As always, it is difficult to convey all particulars to the court and at the same time maintain all duties to the client. February 29, 2022, the hearing was held on Padilla's motion to withdraw. At the time of this hearing, Padilla has been representing defendant for 2 years. Defendant was present for the hearing and was sworn. The court advised Padilla that the court had received a letter from the defendant filed April 20th, 2022, which seemingly objected to Padilla's withdrawal. So she didn't want him to withdraw. The court advised Padilla that the options were not to proceed on Padilla's motion to withdraw or provide the court more about irreconcilable differences. And Padilla was like, okay, let me amend my motion, and that way I can really withdraw for real. The court reserved ruling Padilla's motion, gave Padilla until May 3rd to prepare and file an amended motion. The state advised of Padilla's diligence and preparation, and the court commended Padilla's work. Defendant testified to a lack of trust between herself and Padilla. That's a common theme going on here, lack of trust, whether or not it's with her attorneys, it's with the people that work at the jailhouse, the staff handling her USB drives, the judge, the media. The mistrust is just thrown everywhere. May 4, 2022, Padilla filed an amended motion to withdraw. Undersigned relationship with the defendant has become adversarial. The aforementioned adversarial relationship has interfered with undersigned's counsel's ability to effectively represent his client, especially preparing for a trial. Undersigned appreciates the court by providing him the opportunity to amend his previously filed motion to withdraw. However, after further researching the issue, undersigned is still under the belief that the specifics of the adversarial relationship may disclose information that may prejudice his client, and as such will stand mute on these specifics. Undersigned relationship with the defendant has deteriorated to a point where undersigned counsel can no longer give effective aid in the fair representation of Ms. Boone's defense. On May 10, a hearing was held on Padilla's second amended motion to withdraw. Defendant was present for the hearing and was sworn. Padilla advised the court that he had no other choice to file the motion due to ethical concerns. Defendant confirmed that she wanted to terminate Padilla as her attorney. The state expressed concern of strategy to allow defense attorney after attorney to represent defendant. The court advised defendant of the state's concern regarding a strategy of defendant being unhappy with every attorney and advised defendant about the dangers of self-representation. The court appointed the public defender attorney number 3. Now remember, she had a previously different judge at this point. I think his name was Judge Wooten. At some point, it transferred over to the current judge that we have right now, who Judge Wooten was okay, but I really like this current judge. I think he's perfect with Sarah Boone. I recently watched a video with DB Dara Books and the judge that he was dealing with. She was very patient as well, but I think that the way that she went back and forth with DB sometimes, it was kind of like, I don't know. I feel like this judge would have been perfect for Dara Brooks, I think, as well. Because this judge is like a no nonsense, straight to the point, and then he doesn't entertain back and forth. But who knows? Maybe no judge would be ready for DB. On June 6th, the public defender moved to withdraw due to conflict. Another one moved to withdraw due to conflict. Another one withdrew due to conflict. Oh, never mind. Counsel. Counsel is the one that was mentioned earlier. Counsel is the one that... Mark Consalo. Okay. So Mark Consalo was not the first attorney. So we're looking at Winston Hobson's motion, and then JC responded to the letter to Mr. Hobson when he requested for the $50,000 flat fee, and Consalo was on there. I thought Consalo was like the first attorney assigned, but anyways, I don't think it really matters much. All right, now it was Frank Bankowitz. Now, Frank Bankowitz in open court requested a continuance due to his recent appointment, and it was granted. So a bunch of continuance was filed. There was a status hearing. Now, however, December 9, 2022, Bankowitz moved to withdraw due to irreconcilable differences. I think, July, and then about 5 months later, after Bankowitz has been on the case with Sarah Boone, he put in a motion to withdraw. And if you guys remember, that was not granted. And he had to do another one like 9 months afterwards. But December, Bankowitz moved to withdraw due to irreconcilable differences which have arisen between the undersigned, his client, his family. The undersigned will be unable, I don't know if that was like an error or something. I don't understand the sentence. The irreconcilable differences which has arisen between the undersigned, his client, and his family, the undersigned will be unable to effectively, properly continue representing the client herein. December 20th, 2022, the status hearing was held. Bankowitz did not appear due to, he had a car accident. I forgot about that. So I know it was pushed to December 27, 2022. Sarah Boone was there. She was sworn in. I'm sorry, my husband just called. Now I lost my train of thought. Where were we? I think we're here, right? The court advised defendant. The court had received letters from the defendant, the ones from Sarah Boone. Letter dated October 3rd, 2022. Letter dated November 3rd, 2022. November 7th letter as well. A December 5th letter. This is when she was on a roll writing all these letters complaining about Mr. Bankowitz. The court conducted a Nelson hearing and defendant was not seeking to remove Mr. Bankowitz. Bankowitz advised the court of thousands of pages of discovery that he reviewed and organized and his contact and potential use of collaboration with expert witnesses, including experts that Padilla, attorney number 2, the private attorney, utilized. Bankowitz advised the court of defendant's attempts to call Bankowitz at a rate of 5 to 10 times a day. How was she calling him 5 to 10 times a day? Was she using other people's 15-minute jail calls? I thought once you use it once a day, doesn't that count as even if they don't pick up, doesn't that count? Maybe it doesn't count. Maybe it's smart, it doesn't count. Bankowitz further advised of his efforts to balance the demands of other clients with defendant's expectations for communications. In response, the defendant riposted that Bankowitz's representations were untruths. Ooh. Raised Bankowitz's prior public reprimands. Oh, I remember this. She searched him out. She researched him somehow. I think got someone probably outside of the jail to research him. Raised Bankowitz's public prior remands for lack of communication, alleged Bankowitz's action in this case rose to a similar level, and then sought to remove Bankowitz. The court pointed out that defendants' inconsistent statements within minutes of them being made and addressed concerns over defendants' motivation. The court did the same thing too when she was talking about Patricia Cashman and arguing about that. Oh gosh, that's in a different video. Especially when there is something defendant disagreed with. Okay, I'm going to reread that. The court pointed out defendant's inconsistent statements made within minutes of them being made, and then addressed concerns over defendant's motivations, especially when there is something the defendant disagreed with. The court specifically advised defendant that she is not entitled to an endless line of court-appointed lawyers until you find one that you personally prefer. Now, that was with the previous judge. November 3rd letter sets forth ad hominem attacks on Bankowitz's professionalism. December 5th letter sets forth ad hominem attacks on Bankowitz, including severely mislead and neglect. Let's see. The court advised the defendant that she's not entitled to an endless line of court-appointed attorneys until you find the one that you personally prefer, in quotations. The court also explained the circumstances where defendant could represent herself. Ultimately, defendant did not request to remove Bankowitz. The court denied Bankowitz's motion to withdraw and directed Bankowitz to have a conference with defendant prior to the pretrial conference previously set January 17, 2023. The case was continued several times due to Bankowitz's attempt to retain an expert through JAC and JAC's response to same. Now, during this time period, the court received several letters from the defendant. A letter dated January 10, a letter dated March 22nd, a letter dated April 6th, a letter dated May 15th, and a letter dated June 29th. Oh, sorry, there's more. August 2nd letter, and a letter dated August 2nd. I'm sorry. I think my brain is starting to get a little bit hungry right now. On August 22nd, 2023, Bankowitz again moved to withdraw due to irreconcilable differences arising between undersigned and the defendant that has made it impossible for undersigned to effectively represent his client. It is always, it is difficult to convey all the particulars to the court, and at this time, maintain all duties to the client. See also defendant's quasi ex parte motion for appointment for defense forensic psychologist and request for sealed order e-filed. JAC's ex parte motion, request for a motion for a defense forensic psychologist. So I guess, is Sarah Boone going to scrap the psychologists and not use them? January 10 letter sets forth ad hominem attacks on Bankowitz's professionalism and morals. May 15 letter sets forth ad hominem attacks on the court, alleging that Judge Wayne Wooten was being monetarily compensated from third parties' use of information that is publicly available. June 29, 2023, letter sets forth ad hominem attacks on Padilla, which were not raised during either the April 29, 2022 hearing. So this is her attacking the attorney that she had for about 2 years, and she didn't want him to withdraw. But it's kind of interesting that she's now attacking this attorney in retrospect. I guess because she's probably pissed that they decided to withdraw and things didn't work out between them. Okay, so attack Padilla that was not raised during the hearing or during the May 10, 2022 hearing on Padilla's motion to withdraw as set forth. See page 4. Defendant will not be satisfied with any attorney unless the attorney does not have a caseload and can dedicate his or her time solely to Ms. Boone's case. The best possible avenue is to have the defendant represent herself, as no attorney can satisfy her. On September 8, 2023, a hearing was held on Bankowitz's motion to withdraw. Defendant was present for hearing and was sworn. Bankowitz addressed defendant's derogatory statements like dud, buffoon, and berating behavior. The court advised defendant that the court had received letters from the defendant dated August 26th, dated August 30th, and the court's colloquy of defendant and her acquiescence to Bankowitz's withdrawal. The court granted Bankowitz's motion to withdraw and appointed Winston Hobson. So Mr. Hobson is attorney number 7. He's the one who's trying to file this motion to get Jace to pay him his flat rate of $15,000. Therefore, the court set a status conference for October 3rd at 10 a.m. and a pretrial conference for November 28, 2023 at 9 a.m. After setting these dates, the court pointed out the deterioration of the working relationship between defendant and Bankowitz. The court further cautioned that if this becomes a problem on another court-appointed attorney, I'm going to look at it more closely at what the alleged disputes are. The court further advised that there are certain decisions the attorney gets to make and certain decisions a defendant gets to make, like going to trial or testifying. The court cautioned as the defendant's unrealistic expectations regarding court-appointed counsel and reminded the defendant of her right to retain private counsel, but she can't because she ain't got the money for that. On October 30th, 2023, the status conference was held. Hobson advised as his conversation with the defendant and his setting status in January 2024. Thereafter, the court set a pretrial conference status as to the readiness for trial January 16, 2024. Man, we are in August now. August 2024. Woof. Hobson filed a motion for a continue. January 16, they addressed Hobson's motion to continue. Now on February 1st, Hobson moved to a motion to withdraw due to, guess what, irreconcilable differences, including but not limited to ethical considerations. February 9, 2024, a hearing was held on Hobson's motion to withdraw. Hobson addressed a number of issues as for the basis of withdrawing, including disagreements on legal strategy. That's where I'm saying that, like, I wonder if she has some, jailhouse attorney that's giving her advice and telling her all these things. And then when the attorneys that she's working with, the court-appointed attorneys, are not going through with that, and that's when she's levying all these that's when she's levying all these accusations at them, saying that, like, they're not working collaboration with her. They're not, including her in all these hearings, that they're working against her, that they're not giving time to her, meeting with her and all that stuff. So I just wonder if she already has someone that she trusts and she's going with their legal advice. And when it clashes with the attorneys she's working with, she just starts levying all these accusations, these personal accusations, professional accusations at them. That's what I was trying to say. Okay, there we go. Much better. Okay, so disagreements on legal strategy on what can and cannot be done, a lack of resources, defendant's demand making her difficult to work with, including defendant taking non-viable legal positions and being unreasonable. As to a key substantive defense, Hobson advised that to retain an undisclosed expert is not keeping with what the defendant has in mind. The court advised the defendant that the court had received a letter from the defendant, a letter dated January 19, 2024. The court outlined the overriding claims for withdrawal by Padilla, Bankowitz, Hobson, adversarial relationships, lack of satisfaction, inability to meet defendant's desire. The court found that all of the defendant's relationship with the court-appointed counsel have deteriorated such that defendant and the court-appointed counsel cannot work together. The court advised defendant that although defendant has a right to court-appointed counsel, that right is not unlimited. The court twice advised defendant that defendant may not be provided another court-appointed attorney and that the defendant would have to represent herself if circumstances similar to Hobson's motion to withdraw to occur. So they've been warning her through and through as this is happening in the past couple of years. Of, hey, do you really want to work with another attorney? Do you really want to be adversarial with your current attorney? And, if this keeps happening, then you're going to have to represent yourself. The court further advised defendant about the dangers of self-representation due to defendant's lack of legal training. Yeah. And knowledge. Defendant never stated that she did not understand that she may not be provided another court-appointed attorney. The court granted Hobson's motion to withdraw and then appointed Patricia Cashman attorney number 8. The court is aware of Cashman's extensive experience representing criminal defendants as both an assistant public defender and in private practice, including representing defendants accused of murder, and is widely known to be able and willing to deal with and manage difficult clients. Poor Patricia Cashman. On April 12, 2024, the status hearing was held. Cashman advised as to the depositions that has been set, the hiring of an expert, and a request for a future status date to address a trial date. The court set a status hearing for June 7, 2024. June 7, 2024, status hearing was held. Cashman addressed her date's availability for trial. Defendant was present for the hearing and she was sworn in. Thereafter, defendant advised the court to walking out of at multiple meetings with Cashman, which was confirmed. Cashman utilizing a pretend judge, which was confirmed. Cashman. I thought it was Cashman using a pretend judge. I thought it was Sarah Boone who used a pretend judge, which was confirmed. Cashman utilizing a pretend judge to oversee defendant and Cashman, launching multiple attacks on Cashman's professionalism, providing the court with letters dated June 4, June 7. Cashman advised to her efforts and time spent on this case so far, 20 hours. Cashman addressed disagreements on legal strategy, including defendants attaching importance to issues that may not be legally important. In riposte, defendant accused Cashman of lies and half-truths. June 7 letter sets forth ad hom attacks on Cashman's professionalism and untruth answers. June 4, 2024 letter sets forth ad hom attacks on Cashman's professionalism. Both the June 7 and June 4th letter confirmed defendant connecting and or walking out of meetings with Cashman. On June 11, 2024, Cashman moved to withdraw. Substantial risk that a representation of one or more clients will be materially limited by the lawyer's responsibility to another client. And again, a common theme here, irreconcilable differences, including, but not limited to, ethical considerations, have arisen such that counsel can no longer provide representation. They held a hearing on Cashman's motion to withdraw. At no time has the defendant refused to accept the services of any of her 7 appointed attorneys. This part I thought was interesting, so I'm going to read it. When was that anyways? Law. Both the U.S. and Florida constitutions guarantee an indigent criminal defendant the right to assistance of appointed counsel. The counsel clause of the Florida Constitution under Article 1, Section 16 recognizes the right to counsel as well as self-representation in all criminal prosecutions. Now, the forfeiture of the right to counsel. A defendant in a criminal case can forfeit a right to counsel, a court-appointed counsel, which, that is what happened here. Forfeiture is an extreme measure that flows from the defendant's abuse or manipulation of the right to counsel, and the results in the defendant being required to represent himself even though he was not waived counsel and may still want legal representation. They're citing Commonwealth v. Means in Massachusetts. Forfeiture is a judicial response that adapts the course of the legal proceeding to the defendant's choice to engage in misconduct that undermines the legitimate exercise of the right to counsel. As set forth, defendants' recalcitrance to the attorneys who are not conflicted out Padilla, Bankowitz, Hobson, Cashman, antagonism, hostility, attacks on professionalism of Padilla, notably over a year after the fact of Bankowitz, Cashman, and personal attacks of Padilla, Bankowitz, Cashman. Each of these attorneys were required to withdraw. It has been apparent to the court that the defendant will not permit herself to be represented by anyone, and I'm sure she fucking regrets it now. Additionally, the withdrawal of 8 different attorneys, 7 of which were court-appointed, leads to determination that defendant has forfeited his right to counsel. See Watson v. State. Under Florida law, the facts at bar amount to a binding forfeiture of the right to counsel. As the court finds defendant has forfeited the right to court-appointed counsel, under Florida law, there's no obligation to conduct a forfeiture hearing, and that's what she brought up actually. I think maybe 2 hearings ago. She talked about something about a forfeiture hearing, and I think she was like, why didn't that happen? And then the court was like, if I remember correctly, said like, it doesn't apply to you, or we don't need to do that. There is no obligation to conduct a forfeiture hearing or to otherwise warn a defendant of the dangers of proceeding pro se. Waiver by conduct. The court can find a waiver by conduct to the right of counsel. A. Waiver by conduct requires the defendant be warned about the consequences of their conduct, including the risk of proceeding pro se. February 9, 2024, the defendant was twice advised that another court-appointed attorney may not be provided. May 10, defendant was advised about the dangers of self-representation. February 9, 2024, defendant was advised about the dangers of self-representation. As of February 9, 2024, the instant case has continued 16 times. Oh, gosh. As of June 26, 2024, the case has been pending 4 years, 3 months, 5 days from the date of the filing of the information of March 23, 2022. I wonder if, you know how every time when Sarah Boone writes a letter and she talks about like how much time she spent with her attorneys or how little time the attorney spent with her, she'd be like, she'd have the year, the months, the days, was it like minutes, seconds? Like, it was just such nonsense. I think this is a funny way to kind of like throw it back and jab it at her. I don't know if they're doing it intentionally. Action speaks louder than words. Although defendant's words seemingly reveal a desire to go to trial, however, as set forth herein, her actions and ability to work with court-appointed counsel are repeated over and over. Allowing the defendant to her 8th court-appointed attorney, her 9th attorney overall, will only serve to delay the case further and encourage defendant's persistent efforts to prevent the resolution of the case on its merits. The concept of which was first brought to the defendant's attention on May 10, 2022. Defendant complains that Bankowitz and Hobson, 2 court-appointed attorneys, failed to meet and communicate when defendants provided court-appointed counsel who will meet and communicate, cashman, and the ways and means of meeting and communicating are unacceptable to the defendant. Under Florida law, the facts at bar amount to a binding waiver of the right to counsel. Orders and adjudges as follows. So they're allowing Patricia Cashman to withdraw, and this is where they have Sarah Boone go pro se because she forfeited her right to appointed counsel. Oh boy. Okay, so yeah, I wanted to read this again because, I mean, honestly, when I read it again, I was like, oh, what a refresher. So sometimes when I feel like if I thought something was helpful to me, I will also do it in videos as well. But that's with Sarah Boone. So good luck to Mr. Hobson, Patricia Cashman, Mr. Bankowitz. I hope y'all get paid the amount that you guys work for on this case. And I don't know. I don't know if they're going to have a hearing that's going to be public where they talk about if they're going to split that $15,000 flat fee amongst 3 or 4 attorneys or what. I don't know what they're going to do with that. But oh boy. Okay, so that's all the Sarah Boone stuff that we have for today. I'm hoping to work on other topics as well, but a lot of Sarah Boone stuff just keeps popping up a couple times a week. So I've been busy with that. But yeah, I don't know. We got to cover other cases, okay? We got to do other cases. But I hope you guys have a good one. Take care. Have a wonderful weekend. Feel free to join the Discord. We do have a true crime section. If you guys want me to cover anything, feel free to post it in there. And like I said, any videos that I reference, I'll have it down below. And we've been doing timestamps. So let me know if you guys enjoy the timestamps that we've been doing. That way you can kind of click through the parts that you're interested in, or if you want to rewatch it back later on, you can come back here and do the timestamp stuff, because before I was not doing the timestamps because I was fucking lazy, but I think they're helpful. I don't know, let me know if they're helpful for you guys. All right, have a good one. I'll see you guys. Bye.